Hey, everybody.
Hello,
This,
hello.
this is Sharon,
And
and I am
Donell.
with my business partner.
Hey, Sharon. Good to see you again.
That's Donell.
That is correct.
And we are here with episode 3 of Realtor Life with Donell and Sharon. We are so excited to be here. And
Absolutely.
you might be wondering why we're doing this. Well, we decided that given our vast experience, we've been in the business a combined 20 years or so, coming up on 20 years. We decided that we might be able to help out some agents by sharing some of the things that we've learned in our time as realtors. And born out of that was Realtor Life with Donell and Sharon.
Yep. Third episode.
Our third episode. And we are covering various topics each week. We come to you every single Tuesday at 8:30 p.m. Eastern. And we're hoping that the information that we are providing is helping some realtor, whether it's a new person, someone who is experienced, but maybe has only been selling real estate part-time, and they need a little refresher as they move toward selling real estate full-time. I mean, our whole goal is to help educate our fellow real estate agents and realtors.
Absolutely. Absolutely. Sharon, it's just something I think that there are so many quote unquote gurus out there. And I think for what we're trying to share is that we're real people, real realtors in a real world.
Yes.
We're not any better or worse than anyone else. We're real. And we're giving you real examples and experiences that we have experienced. And as you said, we just want to share with people. And some of the information you may have heard and other bits you may not have heard, but it's just sharing. And through this, we learn, and we're just sharing our experiences so that other realtors can, one, know for sure how to protect themselves and their clients, but also just kind of understand you're not alone out there.
Exactly. And Donell, you mentioned gurus. And one of the things that I have found about gurus, whether you're talking about real estate gurus, network marketing gurus, how to write a screenplay gurus, is that those who can do, those who can't teach. And we want to break that stereotype because we are in the trenches each and every day.
Absolutely.
And
yes.
So we are going to give you real life examples of everything that we're talking to you about. These are things that either Donell or I have experienced firsthand, or we've heard it from a realtor that we're co-oping with, or a realtor friend, or whatever. We are not just going to be talking to you about theory. We're going to be talking to you about real life things that happen in the business, information that you can hear tonight and literally incorporate into your business tomorrow, or even within the next hour.
Absolutely.
So tonight, our topic is the binding agreement date.
That's a big one.
Yes.
That is a big one.
And it is so important that you understand. Hey, Tiffany, I see that you're on. I just logged on to Facebook. And I see that you're on. So thanks for coming on.
Awesome.
But yeah, so the binding agreement date is a very, very important date because everything that we do once a property goes under contract is tied to that binding agreement date.
Yes.
And we just felt like, based on some things that we've had happen, Donell more recently than I have, in dealing with these contracts, that it was important to touch on exactly how the binding agreement date currently works. And I will tell you that how it works has changed. And I think that at least in the scenario that Donell is going to share with you tonight, I think that maybe part of what was going on there is that the realtor was not up to date on how the binding agreement date works.
We
And
hope.
the GAR contract changes every year,
Mhm.
and some provisions might stay the same, some might change. And that's why it's important that you always be current on what the contract says. And sometimes they do a new year change, and they'll do a mid-year change.
Mhm.
So it is imperative, and this is whether you're in Georgia or some other state. When the
Right.
contract changes, it is your responsibility to know what it says. You can't
Right.
rely on someone else to explain it to you. You know, you're representing a client and they're relying on you to protect their interests.
Yes,
So you
absolutely.
got to stay on top of what the contract says.
And just to piggyback on that, Sharon, you go through the real estate course to obtain your license, but your learning doesn't stop there. It's a continuous process. And in our industry, contracts, as you were saying, change on a regular basis, at a minimum every year, certain aspects, but sometimes throughout the year. And with, you've got people that have been in the business, like some of the folks on our team for a few weeks. And then you've got other people that have been in the business for 30 years. There's a wide range of experience and education. And as those contracts change, as you said, what may have been accurate 5 years ago may have changed recently. And with technology, I think we need to constantly stay on top of things, but that's hard because like you said, we're in the trenches, we're working it. And sometimes we just kind of assume I'm too busy to take a look at a webinar or a seminar, which is why things like this are important. A quick way for realtors to take advantage of some of our experiences and have like a little refresher course, if you will, with some of the things. And we can't cover everything, but these are some of the things that we've most recently experienced. And we want to just share those with people because it's more than just signing contracts and going through the process, not really reading. This is the way that you protect yourself, your livelihood, and your career, as well as your clients.
Exactly. Exactly. So I guess without any more preamble, we can go ahead and get into this. And I think what Donell and I agreed to was that we will start by just talking about the provisions of the purchase and sale agreement that pertain to the binding agreement date. So I am going to do a screen share and see if I can pull this up. There it is. Okay, so I am actually on page 8 of the Georgia Association of Realtors Purchase and Sale Agreement. And I have highlighted the binding agreement date area. And I thought I'd just start there because, believe it or not, I have actually received contracts from the co-op agent where they should have bound it, but they didn't do it. So once you have reached an agreement and everybody has signed, that binding agreement date needs to be filled in, and you fill it in with the date and your name, the person who is binding it. And it doesn't have to be a signature. It can just be your typed in name, your handwritten in name, whatever. I try to do everything via e-sign, so mine is always going to be done electronically, but that's up to you. Right. So that date needs to be filled in. But what exactly is the binding agreement date? Donell, yes, I am certain that if we lined up 20 real estate agents and or realtors right now, and we asked them, what is the binding agreement date? We'd probably get at least 10 different answers.
No question about it.
Yeah.
No question. by far is the most important date that you will have in the transaction, but is misunderstood. And if you don't understand this date, because everything kind of hinges on that date,
Mhm.
the inspection, the due diligence period, the finance and appraisal contingencies, the closing date. I mean,
Appraisal
everything.
contingency.
Absolutely. Absolutely. So it's scary to know if you ask 20 and you get 10 different answers, that's a little scary, especially when you're protecting your client. And Sharon, when you really look at it, there's real money tied to this. Clients can lose money if this date is not understood.
Yes.
You know?
Okay, so I am going to scroll up and let's see. I want to go to the definition
That's a
of
good place to
binding
start.
agreement date.
Mhm.
So this is, let me see, paragraph C 5B, paragraph C 5B of the purchase and sale agreement. And I'm going to go ahead and read it. I hate when people read to me, but I'm going to go ahead and read it.
This is okay. we need to hear the words and the real definition.
You know, when I go to a seminar and there is a speaker who is literally just reading their PowerPoint verbatim and they're not adding anything to it,
Right.
that is the quickest way for me to hit the snooze button and to be like,
is not the most exciting information, but is necessary, especially in this case. But yeah, for 2 hours of just reading, that's a sleeping pill.
yeah. So the binding agreement date shall be the date when a party to this transaction who has accepted an offer or counteroffer to buy or sell real property delivers, that word is key, delivers notice of that acceptance to the party who made the offer or counteroffer in accordance with the notices section of the agreement. Once that occurs, this agreement shall be deemed a binding agreement.
That's key.
That's
So
key.
you mentioned a lot of things there, Sharon. I mean, it's only 3 sentences, 3 lines, but I think a lot of people get caught up on accepted an offer and think, well, that's the binding agreement date.
Exactly.
But if the key word that you highlighted was delivers notice, and in a lot of the things, and you're going to talk about this at another point, but everything must be written for notice, or it should be written for notice. Let me say that. We can agree to go to a restaurant at 3:00. But if it's not written in real estate, you have to write it so that we both understand it and deliver. So if it's not delivered, it's technically not a binding agreement. Is that your understanding of this definition?
That is my understanding. And why don't we just scroll right on up to paragraph 4. What is it? C. Did I say C? Yep, C4 to talk about notice of binding agreement date.
Mhm.
And this says the binding agreement date shall be the date when a party to this transaction who has accepted an offer or counteroffer to buy or sell real property delivers notice of that acceptance to the party who made the offer or counteroffer in accordance with the notices section of the agreement. Very similar to what we just went over in the definition of binding agreement date.
Right.
Notice of the binding agreement date may be delivered by either party or the broker working with or representing such party to the other party. If notice of accurate binding agreement date is delivered, the party receiving notice shall sign the same and immediately return it to the other party. And so we're going to delve into the notice of binding agreement date when we're going over Donell's scenario.
Okay.
So that's notice of binding agreement date. But we still need to get to the notices section of the agreement. So that's paragraph C1, A, B, and C. And this is really important. Let me move myself out of the way so I can see this. C1A says generally, all notices given hereunder shall be in writing, legible, and signed by the party giving the notice. In the event of a dispute regarding notice, the burden shall be on the party giving notice to prove delivery. The requirements of this notice paragraph shall apply even prior to this agreement becoming binding. Notices shall only be delivered, listen guys, in person, by courier, overnight delivery service, or by certified or registered U.S. mail, hereinafter collectively delivery service, or by email or facsimile. The person delivering or sending the written notice signed by a party may be someone other than that party. So a text message is not notice.
It's not listed here.
A phone call is not notice.
It's not listed.
And there are so many agents these days who want to hide behind text messaging.
Right.
And, you know, they're doing themselves a disservice. They're doing their clients a disservice. And it's important that we remember, you know, sometimes we're like, okay, whatever, you know, it's not that big a deal. But when it comes to the contract and those time frames go by so quickly.
Yes.
This is where you need to play hardball with somebody who thinks because they sent you a text message telling you that their client accepted the offer, that is notice. It is not.
It is not.
And
it's clearly stated.
Yes, you've got to have enough backbone to challenge them and say, no, I'm sorry. I haven't received written notice from you. That text message, according to paragraph C1, A, is not notice.
Well, Sharon, I think that while you can tell when this was originally written by the Georgia Association of Realtors, they mention things that we don't, I mean, life has changed over the last 10, 20 years. So you can notice, you can see in the notice, number one is in person, by courier. Most people don't deliver real estate things by courier anymore.
Right.
Overnight delivery service, certified or registered mail. But this says you could deliver notice these ways, even though most people don't. The big one is number 3, by email or facsimile. Now, most people say facsimile, who even has a fax machine?
Right.
But email, we still use email on a regular and consistent basis. Now, the next level of communication, so to speak, or the most recent, as you said, is texting. They have not added texting to this document.
Right.
So until they do, and if, God forbid, you ever have to go to court, they're going to come right here and they're going to see what are the acceptable means of notice.
Exactly.
So we need to understand that, and like you said, sometimes, you know, we all try to be nice and nobody really wants to get into an issue. But in some cases, you got to stick to the letter of the law, and it's written right here. You know, it's got to be one of these forms of communication. If it's not, notice has not been given.
Exactly. All right. So C1B, delivery of notice. What constitutes delivery? That is, beside it being in writing, it needs to be delivered. Those two things are critical. So C1B says a notice to a party shall be deemed to have been delivered and received upon the earliest of the following to occur. 1, the actual receipt of the written notice by a party. 2, in the case of delivery by a delivery service, when the written notice is delivered to an address of a party set forth herein or subsequently provided by the party following the notice provisions herein, provided that a record of the delivery is created. In the case of delivery electronically, on the date and time the written notice is electronically sent to an email address or facsimile number of a party herein, or subsequently provided by the party following the notice provisions herein. Notice to a party shall not be effective unless the written notice is sent to an address, facsimile number, or email address of the party set forth herein, or subsequently provided by the party following the notice provisions herein. That
Okay.
is so critical.
Okay, now Sharon, now, I know you have a legal mind and background, and we're appreciative of that. But that's a lot of mumbo jumbo to me as a regular layperson. I'm just gonna tell you straight. Can you explain what all that means in simple
Okay.
terms?
To break it down into layman's terms, what it means is that it has to be in writing. It
Okay.
has to be delivered either to an email address, a physical address, or a facsimile number that has been provided by the party. So if I'm the buyer and I'm delivering notice to the seller, I would have to send it either to the seller's email address, the seller's agent's email address, the seller's fax number, the seller's agent's fax number, the seller's physical address that they have provided in this document or in another formal document, or to their broker's address.
Okay.
Those are the only ways, and it must be in writing.
Okay. So I can't
So
just tell you. I can't just tell
They
you.
can't just tell me,
I can't text you.
can't text me, can't send a
Okay.
carrier pigeon.
I can't do mental telepathy.
Nope.
It was implied.
Can't call me,
Can't call. Yeah. Okay.
can't call.
Okay.
And, so that's just really important to understand. This delivery is very limited. What constitutes delivery is very, very limited.
Mm-hmm.
And, we'll get into a little bit later how it used to be,
Mm-hmm.
just for the sake of comparison.
Sure.
And then let's talk about C1C.
Before we leave that, Sharon, I just want to just literally very quickly. You've told us how we need to or can acceptable ways to deliver notice. You mentioned email. Suppose there was when the agent was writing down the email, they transposed some numbers and it was sent to what they thought was the correct email. But the person never got it because the email address was wrong. What would happen in a scenario like that?
That would not constitute notice. So if, for instance, my email address is sharon.smoot@exprealty.com. If someone called themselves emailing me and left that dot out and sent it to SharonSmoot@exprealty.com and I never got it, that would not constitute notice. It says that in the case of delivery electronically, its delivery is considered the date and time the written notice is electronically sent to an email address or facsimile number of a party herein. So if you make a typo,
it wasn't sent to the party.
It wasn't delivered.
It wasn't delivered. Yeah.
Yeah.
So I just bring that up because people can say, well, I sent it to you. Well, which address did you send it to? And they give the address and that's the wrong address. Well, I never received it, but I sent it. So we should be minding. You're not.
Exactly. And that's where you have to be tough, because a lot of agents want to, just kind of ignore the provisions of the document. And like I said, if they sent it on Sunday with the binding agreement date of Sunday, what day was that? The 22nd?
Mhm.
And your due diligence period is 3 days, and you're waiting for the contract, waiting to get it back. Are we binding or not? And then you have a conversation today and they're saying, well, I sent it to you, and you discover that they sent it to the wrong email address. And they're trying to say, well, we reached an agreement on Sunday, so that's the binding agreement date. Well, then that means that you would only have a 1-day due diligence period.
Right.
And it was not delivered. And so
Mhm.
that delivery is the linchpin of this whole thing.
Absolutely. Everything hinges on that.
Yes.
Everything.
Yes.
So very critical day and the delivery of that day. And we'll get into some of the other things that could go awry later on, but I'll let you continue so that we stay on time here. But I've
Yeah,
got
so
some
that
other
we don't
comments later on.
run too far over. Okay, so when is the broker authorized to accept notice for client? Except where the broker is acting in a dual agency capacity. And at EXP, we don't do dual agency. I think a lot of the major brokers don't, but
Right.
if you are with a brokerage that allows dual agency, you need to be really careful about what you can and can't do on behalf of your client. And accepting notice is one of them. If you are
Right.
representing the buyer and the seller, then each of those parties has to receive notice directly. You can't be the go-between.
Mhm.
So, except where the broker is acting in a dual agency capacity, the broker and any affiliated licensee of the broker representing a party in a client relationship. Notice it doesn't say client or customer, just
Mhm.
client relationship shall be authorized agents of the party, and notice to any of them shall for all purposes herein be deemed to be notice to the party. Notice to an authorized agent shall not be effective unless the written notice is sent to an address, facsimile number, or email address of the authorized agent set forth herein or subsequently provided by the authorized agent following the notice provisions herein. So that's what we were just talking about,
Mhm.
where they send to the wrong email address.
Right.
And except as provided for herein, the broker's staff at a physical address set forth herein of the broker or the broker's affiliated licensees are authorized to receive notices delivered by a delivery service. The broker's staff, and the affiliated licensees of the broker shall not be authorized to receive notice on behalf of a party in any transaction in which a brokerage engagement has not been entered into with the party, or in which the broker is acting in a dual agency capacity. In the event the broker is practicing designated agency, only the designated agent of a client shall be an authorized agent of the client for the purposes of receiving notice.
Okay.
And I think that would probably be a good topic for another night to talk about the difference between dual agency and designated agency.
Absolutely. Absolutely.
So those are the high points in the contract having to do with the binding agreement date.
Mhm.
Let me see. I think that's it. Yep, that's it. So, Donell, do you want to go through your scenario first?
Sure. Sure. I'll be glad to share it.
Before you get started, let me ask Tiffany. Oh, no, it doesn't look like she's still on, so I don't think she has any questions. So go ahead. Go for it.
Okay. So in this particular transaction, was representing a buyer. Okay. So I showed a buyer a property. He liked the property, and we decided to put in an offer on the property. We listed all of our terms, and with this particular offer, we had a 30-day closing.
Mm-hmm.
Okay. During the course of, let's just say we entered it on the 5th with a expected closing date of the 5th of the next month, 30 days roughly. Well, say we entered it on a Saturday. They didn't get back to us with a decision until, say, Tuesday of the following week. So a few days passed. Okay. So in that scenario, we had already lost 4 or 5 days, which was no biggie. But, and Sharon, I don't know if you, I'm seeing you're still sharing your screen.
I just took the screen share off.
It's still, okay, okay. So in this scenario, we had lost 4 or 5 days, no big deal from the lender's perspective, okay? But when we got the offer back, first the agent called me and said, we're going to accept your offer. No problem, great, we're excited about that. He said, can your buyer close sooner? And I said, well, originally, had we gotten it done, a few days earlier, we would have had 30 days, but we're still at like 26 or so, which is still okay for the lender. The lender needs 30 days officially. He said he might be able to close it in 20, but he would prefer to have 30 so that he's got some leeway just in case there are any delays. And he said, okay, well, that sounds reasonable.
Mm-hmm.
We're going to go on and get the seller to sign your offer, and we'll be out the door, which he did. We got the offer back. It was signed by the seller and the agent. The problem, though, Sharon, was that the closing date that we originally had on the offer was X'd out. And they wrote in what they wanted, which was around 21 days. And they did not initial it, but they did bind it and send it back to us. So in essence, we got, when you look at it, it looked as if we agreed to close in about 20 or 21 days, which is not what we intended. And he thought, without signing himself or us signing that change, that we were binding.
Mm-hmm.
So here's a scenario where just because you sign that binding agreement date that we talked about earlier, that doesn't mean that it's binding if some things have changed in that date. And then you get to the delivery. The delivery had one date, but he actually, the date for binding had one date, but he delivered it to me like a day or two later. So there are multiple things in this scenario. The first of which is he thought we were binding and we were not. Because once you
what
cross
you had
something,
was a counter offer. His
it was
client
a
made
counter
offer.
Exactly. So, and we'll just delve into that really quick. Obviously, the binding date is what we're discussing here. But subset to that binding date is you're binding and agreeing, both parties are agreeing that everything contained within this document is acceptable as is, no change.
Mm-hmm. Mm-hmm.
But once you make a change, you got to initial it for one, but then you have to give the other party a chance to initial it as well.
Exactly.
Neither one of those things happen. So even if you put the date on there as binding, it's not binding. And I think sometimes people, and we had this in a previous episode where someone wrote the date in that they wanted it to be bound, but it was 2 or 3 days prior to you actually delivered it. And based on what we've read tonight, it's the delivery has to be written and it has to be delivered. Exactly.
And Donell, several years ago, the way the contract was written, it just gave a lot more latitude as far as what constituted notice. And so I think what a lot of agents relied upon was that, they might email you and say, my client's accepting the offer. And they would put, if they emailed me today and said, my client's accepting the offer, and I acknowledge the email, okay, great. They don't send me the contract until tomorrow or maybe the next day, but they put the binding agreement date as today because we've had that conversation, via email. But the way the GAR form is written, that email communication does not constitute notice because it's got to be signed by a party to the agreement.
So you bring up 2 points. If you're working with another agent, and just say you're representing the buyer and you're working with a listing agent. So they email you and they say, well, I emailed you that we were going to accept your offer yesterday. I gave you a written notice and I delivered it to you. You delivered the email. You didn't deliver the offer. So it's not just you just saying, I emailed you and we're good to go. We're binding. Well, you didn't bring the offer with it. And even and the reverse is true as well. You could sign it 2 or 3 days ago, but you didn't deliver it to me via courier, in person, email until 2 or 3 days later. That is the actual binding date.
Exactly.
Yeah.
And, you know, there might be circumstances where maybe for whatever reason, there's a delay in delivering that written notice. And that's where the notice of binding agreement date might come in. So you might not be able to get the contract where the binding agreement date has been filled in over to the other party or the other agent immediately. But you can use the binding agreement date notification form. So let me see if I can pull that up. Just one second. Let's see. There we go. And this form is real simple. This is the binding agreement date notification. For those in Georgia, this is form F819. And if you're not a realtor, if you're using those real estate forms, there's something similar. I don't know what the form number is. But anyway, it says you identify the parties and the property address. And then paragraph 1 is where you put in the binding agreement date. So in your example, from a couple weeks ago, where it was 3 or 4 days after he told you that his client was going to accept the offer, that you actually received the fully executed agreement, and he had put a binding agreement date of 2 or 3 days prior. What he could have done was fill out this form, put in the date that he notified you that the agreement was going to be accepted, that the offer was going to be accepted, and then it gives the definition of the binding agreement date, and then fill in the date that he's delivering it to you.
Okay.
And then the buyer and the seller have to sign it to make it official. But that is one way to kind of get around if there's going to be a delay in actually getting the fully executed purchase and sale agreement to the other party.
Well, to me, one of the things that is key, and this word just keeps coming up every week, is notice, notification, notice, notification. Meaning you can do something, but if you don't notify the other party, it's as if you didn't complete the action, the full action. It's great that you got everything signed, but you didn't deliver it to the other person. So you're going to have some confusion there, possible confusion. So this is just good to go over. Why don't you tell us about your scenario? I think you had an interesting one as well.
Yeah. And this was just over a year ago. My client had listed her property in Ellenwood, and we got multiple offers, and she elected to accept one of those offers. And I talked to her about holding one of the other offers as a backup. And she said, yeah, that sounds good. So I notified the selling agent for the backup offer that my client would be willing to hold it as a backup, you know, and she said, oh, great, you know, my client really wants the house. So I prepared the backup agreement contingency. I had my client sign the purchase and sale agreement, but it wasn't binding because that backup agreement contingency needed to be executed. And there is some very specific information that needs to go into that backup agreement contingency. You have to have the name of the primary buyer, the date of the primary offer, and the date that that backup agreement contract becomes void. So in other words, if that backup agreement has not become the primary within a certain time frame by the date specified in that backup agreement contingency form, then it's automatically void.
Wow.
So,
Okay.
like I said, I sent her the purchase and sale agreement along with the backup contingency for her client to sign. And my expectation was that she would have her client sign it or initial it. I don't remember whether it's a signature or initials, but that she'd handle that and get that form back to me, and that she would bind the purchase and sale agreement.
Okay.
Well, I never got anything back. And I called her, I emailed her, I sent her a text message. And finally, after 3 or 4 days, I received a backup contingency form that she has drafted.
Okay.
In the spot for the primary buyer's name, she had put her client's name.
Which she wasn't the primary.
Right.
She's the backup.
Right.
Okay.
And the spot for the, what I'm going to call the drop dead date, she had put a date that was like maybe 2 or 3 days into the future.
Mm-hmm.
And so I was like, well, I can't have my client sign this. It doesn't make any sense. It's incorrect.
Right.
So I notified her again.
Mm-hmm.
Can you please have your client sign the backup agreement contingency that I sent to you with the purchase and sale agreement that my client had signed?
Mm-hmm.
No response. Well, long story short, the primary buyer ended up terminating. And so I reached out to this agent and the other agents who had submitted offers to let them know that the property was back on the market, and if any of their clients were still interested, to have them submit another offer. And she immediately called me and she said, oh, has anybody else submitted an offer? And I said, no, not yet. I said, so if your client still wants it, you just need to update your offer and send it over, which she did.
Okay.
Well, my client makes a counter offer. And I sent the counter offer because I do everything in writing. I don't send no email talking about these are the terms of the counter. I don't send it by text. I use the counter offer form.
Sure.
So
Make
my
it official.
client signed that. I sent it to her and she calls me up and she's like, how can your client be making a counter offer? I mean, I'm really agitated.
Mm-hmm.
And I said, well, you submitted a new offer on the property, so she's well within her rights to make a counter offer. Well, no, we had a binding agreement. And I said, no, we did not have a binding agreement.
Mm-hmm.
And you know what, Donell? I didn't even ask you any questions about your scenario.
It's okay. We'll come back to it. This is interesting.
Okay.
I want to hear how this goes.
It just hit me. But anyway, she says, yes, we did have a binding agreement. And I said, no, we didn't. I said, because your client never signed the backup agreement contingency. Mm-hmm. I said, I sent it to you when I sent you back the signed purchase and sale agreement. You did not have your client sign it. And she said, but I sent you one that she had signed. I said, yeah, you did, but it was incorrect. And I notified you that it was incorrect and asked you to have your client sign the one that I had sent to you. So we get off the phone and next thing I know, I'm getting an email from this chick. And she's like, I spoke with my broker. And as I suspected, we do have a binding agreement.
Oh, really?
Yeah.
Really? Oh,
yes.
Okay. Here we go.
Here we go. So it was interesting.
It sounds like it. So Sharon, it doesn't sound like, just listening to you, it doesn't sound like she was malicious in her intent. It sounds like she just was uneducated in the process.
She was pretty
And the broker
new.
too, possibly.
Whenever I have any kind of, conflict or whatever with another agent, one of the first things that I do is go look at their license number to see how much lower it is than mine or how much higher it is than mine. And hers was significantly higher than mine, which signaled to me that she'd probably been in the business maybe a year or two.
Okay.
And so I think that, just based on this incident and some other things that happened during the transaction, I think she was just really, really green and didn't know.
Yeah.
And thought she knew a lot more than she really did.
Yeah. And that's understandable. I mean, that's why we're doing what we're doing now, is to help fill in some of those gaps.
Exactly.
So one question I did have for you is, when did you receive that email from her that, she wanted to move forward and all of that? Because it sounds like there was some time. And as you were explaining it, I thought of another question. This form that you were speaking of asked for the primary buyer. So she's going to be the backup. Okay. So it sounds like when she sent you that second form, she wouldn't know who the primary buyer was unless she got that information from you.
Exactly.
Which is why you wanted her to sign the form that you sent over originally. Is that right?
Yeah. Yes. Yes.
So why would she think she could just cross that out and just put anything in there?
Well, Donell, what I found out, because, once she sent me that email, I spoke with my broker, and as I suspected, we do have a binding agreement. Well, Donell, you know me.
Yes,
and
I do.
You know what I did.
Yep.
I picked up the phone and I called the broker. And she is with one of the brokerages that has brokers on duty. And so, they have several. And when I called, I did not speak to the same broker that she had spoken to, but the person I spoke to could see in the notes that this young lady had called in. And so I just said to her, she seems to think that we were in a binding agreement. I said, and I want to make sure that you understand exactly what happened. And so I ended up explaining it all to her. And she said, can you send me a copy of the agreement signed by your client and the backup contingency that you sent to this agent, which I did. And she said, give me a few minutes. After I get it, I'll review everything. I'll talk to her and I'll give you a call back. And when she called back, she told me that the young lady said she never got it. And I said, but did she say that she got the agreement that had been signed by my client, the purchase and sale agreement? And she said, yes, she did. And I said, well, there's no way that she couldn't have gotten it because I sent them in the same email.
Right.
And she said, yeah, I understand. Oh, and that was the other thing. I forwarded her all of the emails.
The evidence.
To that point, so that
the
she
evidence.
could see, yes, the receipts, the receipts.
Yeah.
So, we got it all worked out, and that her client ended up buying the house.
Okay. Well, good.
So, but one of the things that I always do, Donell, whenever there's a backup, I like to formalize it so that there are no misunderstandings about the binding agreement date, because with the backup agreement, some of those deadlines don't start to run until the backup agreement becomes the primary agreement.
Right.
But you want to be locked in because there can only be one backup agreement. I can't have, this young lady in a backup agreement and then Joe Blow in a backup agreement and Yosemite Sam in another backup agreement. And I think a lot of the times agents, really play fast and loose with backup offers. Oh, well,
Right.
my client says that you can be the backup. And then I said, well, what can we formalize it? And it's crickets.
Mm-hmm. So go over formalizing, because you mentioned that. And while you were mentioning that, I've entered offers and they say we're accepting backup offers. Okay. And you're position number 3. It sounds like that is not appropriate. You can only have one backup offer.
You can only have one backup offer
Okay.
because the language in the backup agreement contingency says this is the primary buyer.
Mm-hmm.
This is the date by which this document will become void if the backup buyer has not become the primary.
Mm-hmm.
So if Joe Blow is the backup buyer,
Mm-hmm.
Yosemite Sam can't also be the backup buyer, because in order for Yosemite Sam to be the backup buyer, Joe Blow would have to become the primary buyer.
Right.
And so there's no way to effectuate that in, the current state of affairs with the Georgia Real Estate Commission. So they might, in their minds have you as the backup, but if it's not in writing, it means nothing.
So, and that's actually a topic for one of our future episodes, just backup offers in general, because as you mentioned, and this happens in today's world, especially at this time with things so, hectic for realtors and buyers and sellers, fast and loose seems to be a very appropriate term for where we are.
Yeah.
And some people don't know, and some people may
Don't
know,
care.
but they don't care. That's a better way of saying it.
Yeah.
Yeah, you're right. You're absolutely right. So,
but
I didn't mean to get off topic, but could you talk about the formalizing that offer? Because that's where you were originally going.
Formalizing the backup, that means that the seller has signed the purchase and sale agreement, that you've agreed on all the terms in the purchase and sale agreement, and that the backup contingency agreement has been signed and that the contract has been bound. That's formalizing it.
Okay.
And if that hasn't been done, there really is no backup offer.
Right.
Now they might come to you and say, hey, the deal fell through and my client wants to move forward with your client if they're still interested. But in those circumstances, your client would need to submit a whole new offer.
Okay.
When you have formalized the backup agreement, everything's already been agreed to. So like in my scenario, if she had just done what she had said she was going to do, or what I had asked her to do, then my client would have been locked in at the sales price that her client initially offered. She had initially offered $150, I think, and my client countered with $155. If she had done what I asked her to do by having her client sign the backup agreement contingency, my client would have been stuck with that $150.
But because she didn't, that opened the door
for my client to make a counteroffer. Exactly.
Yeah.
Exactly.
Which goes back to, again, our original topic of the binding agreement.
Exactly.
I mean, that's we're seeing some consistent themes each week. Notification, binding agreement, and all these things kind of tie in together from a holistic standpoint.
Yeah.
Yeah.
But Donell, I wanted to go back to your scenario and ask you a question. Like when you told the listing agent that you didn't have a binding agreement, what was his reaction? I mean, did he try to challenge you? Did he argue it?
No, this was the reaction. Silence. Crickets. I never heard anything else. I did hear back from him a day or two later, but at that point we just kind of skipped over that and went into, okay, well, what do we need to do and during this time, and let me just add this, during that time of ambiguity or confusion or silence. My client was going ahead and getting some information from the county as far as some of the, due diligence. He was using that time to his advantage. So that once we actually did go binding officially, he would already, in essence, have some of his due diligence work already done so we could go on and get the thing done, should we come to an agreement. We later found out that there were some things that prohibited him from moving forward with the deal. But to answer your question, when the listing agent found out, I mean, he never really addressed, like you said, there were crickets. And once he did come back, it was, okay, well, what do we need to do to get this corrected and move forward? Because we really want to work with you. And I said, well, at this point, we'll know in a few hours because, the client is waiting for some information from the county on permits, et cetera, et cetera. And he said, okay, great. Well, if he likes it and wants to move forward, we'll do a new agreement. If not, we'll just terminate, which we really had nothing to terminate because we weren't binding in the first place.
Yeah. So do you think that him changing the closing date and treating it like it was a binding agreement, even though his client hadn't initialed the change, I mean, do you think that he did that on purpose, or that, that it was malicious or
Sharon, there's
deliberate?
no
I
way.
guess is a better word. I don't want to say malicious, but
Yeah.
deliberate.
You never know what's going through people's minds. And as we've talked about in previous episodes, you assume ignorance until you know malicious, so to speak.
Yeah.
I mean, because you want to assume, well, a person just didn't know and they just did this. And this person had been in the business, like you said, based on their realtor number, a significant amount of time, much longer than I've been in the business. But again, we've said this before, just because you go to church doesn't mean you know the Bible.
That's
and
true.
I had to, I mean, but Sharon, that one was one that a realtor just coming out of realtor school knows. Anytime you make a change, both parties, especially your party, has to initial it.
Right.
But ultimately, both parties have to initial that change.
And you know what, Donell, that is an old school way of doing things. Like when I got into the business, there was no counteroffer form.
Okay.
You made the changes, on the contract and the parties initialed it. That was standard. And so I was thrilled when they came out with the counteroffer form.
Right.
And I use it religiously. And, that's just my preference, so that there is no confusion about what you're countering.
Right.
But that's
very
just
clear.
me.
Yeah, very clear. And that's, we talked about this. Most of the things, when I explain to clients, when we're going through the buyer brokerage agreement and all the other many forms that they have to sign, typically you're signing something because there was some confusion in the past. Possibly someone got sued or sued someone, and now they don't want that to happen again. So they're coming up with a new form, a new paragraph to clear things up and make it very clear so that there's no gray area of confusion, or as much as they can. So in this case, what you're describing and just initialing any change just protects everyone with a very clear intent. And to answer your question, we're going to assume ignorance versus him just trying to be deliberate or malicious.
Yeah.
But you never know. At the end of the day, we don't have to worry about it because the contract was not binding to begin with.
Right. And, it really could be a situation where he just didn't know, because like we talked about at the top, that contract changes every year.
Yes,
and
it does.
Maybe you don't have time to go to the webinar or to attend the CE class where they explain the changes, but ultimately it's your responsibility to know what the contract says.
Absolutely.
And so it could be that he's operating back in 2013
or 5.
Who knows? Right.
But sharing the other side of it is this: if you don't know, and things change all the time, if you don't know, listen, learn. Just what we're doing here. I mean, we've been in the business, as you stated, combined almost 20 years, and we still learn new things on a fairly regular and consistent basis.
Yeah.
And we thought we knew this, but the reality of it is, nope, that's actually changed to that. So if you don't know and someone tells you, I don't think you should get an attitude and get offended. Like, who are you to tell me? Just look at it like, you know what? There is a possibility that I'm wrong. Well, let's check it
You know
out.
what, Donell? I had a situation a few years back where the GAR form changed, and this is having to do with the counteroffer form. And it said that the new change was that by virtue of signing the counteroffer form, that all exhibits are deemed signed. And that was a new change. And I just hadn't digested that
Mhm.
in that form. And another agent brought it to my attention when I said, well, is your client going to sign the exhibits? And she said, oh, we don't have to do that anymore. And
Mhm.
and she told me, she said, look at paragraph whatever of the counteroffer form,
Mhm.
which I did. And I was like, oh my goodness. And I said, thanks so much for
Right.
bringing that to my attention. I said, I had not, caught on to that yet. And
Mhm.
because I hadn't gone to the class on the changes to the
Right.
contract.
Right. Absolutely. But you were open to learn and accept that. And for moreover, she gave you a reference point. Go to this page, paragraph, blah, 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 and you can read it for yourself. Now, don't just
Exactly.
trust me, because again, you have more of a legal background than I do. I'm reading it and it's saying it in black and white, but I may not understand it,
Yeah. Yeah.
And in
And
that
there's
case,
a lot of
either ask another person or
legalese.
ask your broker.
Yeah. And exactly. That's what the broker is there for.
Mhm.
And, unfortunately, in my scenario, the young lady, I mean, she just really thought she knew so much more than she really did. And
Right.
so she didn't even present all the facts to her broker so that her broker could advise her.
Right.
So I had to send the correct backup agreement contingency plus the incorrect one. And I told her
Mhm.
broker, I said, there was no way I was going to have my client sign that document that she sent over because
Right.
it was just wrong.
It's just flat out wrong. Yeah.
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 And it was meaningless. It would not have
Mhm.
bound my client to anything because it was meaningless.
Mhm. Right. Right.
So
Yeah. Good
anyway,
information.
let me see. I think Tiffany has left us, but that's okay. So Donell, you know how we love to wrap this Realtor Life with Donell and Sharon up.
Mhm.
We are always looking for
Always.
dedicated, motivated,
Mhm.
hungry realtors to join our team.
Absolutely. All the time. We are building our team. EXP is a great opportunity. A lot of fun and exciting things, a lot of creativity. And we've already had some great success, and we're looking for other realtors that are just looking for something different, looking for things like this. This is one of the things that Sharon and I came up with, but there are many other things that you are afforded. And if you're interested, by all means, reach out to Sharon and I. We'll put our contact information in the chat window. And just feel free to reach out to us, and we would love to speak with you if you have any questions or if you just want to chat.
That is right. We love EXP. I had been with my former brokerage since I got my license, did not envision a change. And here I am. I've been with EXP for almost a year. It'll be a year, I think October 1st. And I have nothing bad to say about my other brokerage, but I am so glad that I made the move. And, like I said, we are just looking for great agents, whether you're experienced or not. We would love to have you if you have the right attitude, if you're looking for someone to partner with to provide guidance and mentorship. We are willing to do that, to support you as
Absolutely.
you build your real estate empire. And the best thing about it is that it doesn't matter where in the country you are. It doesn't
Right.
matter where in the world you are. We, EXP, has brokerages in how many different countries, Donell?
Currently 11 and looking to expand to 13 very soon.
Woo!
11
I mean,
countries.
that is just so exciting. It is so exciting.
And Sharon, to that note, I'll just say you mentioned the experience. We've got people that just recently passed their real estate exam.
Yep.
And then we've also got people that are brokers in other states that have teams that saw something and wanted to be a part of our team. And we're appreciative of them. So it doesn't matter wherever you are in the country or the world, as Sharon mentioned, EXP has something for you, and we'd love to have you on our team.
Yep. So if you're curious about what EXP has to offer, you can reach out to Donell or I. Our contact info is in the chat. And if you are watching this on Facebook, I will add our contact information to the description of the video when we're done. And if you're looking at this on YouTube, my contact information will be in the description there as well. And that's on my YouTube channel. I don't think that Donell has a YouTube channel yet.
It's in development.
It's in development. So, you know, we got to bring Donell into the social media age, but
I need a little help, but it's all good.
We thank you so much. If you're looking at the replay on Facebook and you like the information that you're hearing, give me some hearts, some thumbs up. If you don't like the information, give me some angry faces. If you're surprised by anything that you've heard, give me some wows. Just let us know that you are watching and that you appreciate what we're doing. And even if you don't appreciate it, that angry emoji is okay. We just want to know that you're hearing us.
Absolutely. Any kind of feedback is appreciated. And we really do appreciate you taking the time to listen to what we have to share and be a part of what we're trying to do here.
Yes. Yes. So that is it for tonight. Thank you so much. And we will be back again next Tuesday. I think that is August 31st at 8:30 p.m. Eastern Time with episode 4 of Realtor Life with Donell and Sharon. Take care, everybody.
Thank you. Have a good night.
Bye-bye.